Now, good morning. I am Lord Brailsford, Chair to the inquiry, and I'd like to thank you all for attending our first public hearing. I am honoured to have been entrusted with such an important undertaking on behalf of the people of Scotland. Let's adjust this mic a little bit. Today I'm here to share with you the approach I intend to take to the task I've been set, which is to establish the facts of and to learn lessons from the strategic response to the COVID-19 pandemic in Scotland between the 1st of January 2020 and 31st of December 2022, the period covered by this inquiry. Before we begin, however, I would like to address bereaved families, care home relatives, and all those of you here today and watching online who were impacted by the pandemic and who are looking to this inquiry for answers. We all hold at the forefront of our minds the very difficult and distressing experiences so many have had. In particular, we remember those who have lost their lives, those who were separated from their families, key workers who did all they could to alleviate suffering, and the many people who are still affected by COVID-19 and the pandemic. I wish to express my sincere condolences and those of the inquiry team to those of you who lost relatives and friends to COVID-19. I would now like to invite you to watch a short film as we reflect on the impact of the pandemic on the people of Scotland. This film is intended as formal and lasting recognition of the suffering caused by the COVID-19 pandemic. You may find some of the images and words in this film distressing, and you may prefer not to watch. I will pause for a few moments for anyone to leave the hearing room or suspend the live stream if you are watching online. I should tell you that the film lasts a little over 11 minutes, so we'll pause for a moment or two. Well, it doesn't appear as if anyone wants to leave, so could the film please start? Now, I'm sure the film has brought back many memories for all of us in this room and those watching online. I can tell you it will be published on our website and can be viewed throughout the lifetime of the inquiry. The purpose of this preliminary hearing today is to provide you with an update on the work undertaken by the inquiry to date and to set out our plans for hearings this autumn and the relevant processes and protocols. What we will discuss today relates only to our health and social care hearings. Further information about our approach to future sets of hearings will be set out at a later date. This preliminary hearing and the inquiry itself is not a court. We are not here to determine criminal or civil responsibility. we are here to examine what happened in Scotland in a non-adversarial manner, working with core participants and gathering and analysing the experiences of people across the country. While you do not need to be a core participant to engage with the inquiry, these organisations have some additional rights. We have 37 core participants to this inquiry, many of whom are with us in the room today. They play a central role working with the inquiry to fulfil its terms of reference and ensure our terms are met. When I was appointed chair of this inquiry by the then Deputy First Minister in October 2022, I was under no illusion as to the importance and magnitude of the inquiry's work. The COVID-19 pandemic presented the most severe health crisis in living memory. It affected everyone. More than 17,700 people have died in Scotland, with COVID-19 listed as one of the causes on their death certificate, many without being able to say goodbye to their loved ones. And thousands of people are still living with the consequences, including those with long COVID and others whose mental health has suffered because of the pandemic. Care home residents and many of those required to shield because of underlying health conditions had long periods with no contact with their families and friends. And some people were unable to receive the medical treatment they urgently required. Young people's education was disrupted and educational opportunities were missed. Businesses faced financial hardship, some of them failed and jobs were lost. Health and social care workers faced huge pressures as they sought to save the lives of critically ill patients and keep us all safe. They, along with teachers, police officers, and thousands of other emergency and key workers, risked their lives in the course of duty. Politicians, local government leaders, NHS boards, and others found themselves in an unprecedented situation and were required to respond to a virus that was spreading rapidly and mutating. They had to make decisions at pace that impacted upon the entire population. They shouldered this responsibility for many months. I will conduct a robust investigation without fear or favour that will arrive at the facts, identify any lessons that need be learned, and make recommendations to Scottish ministers so we are better prepared in the event of any future pandemic. I will not take sides, and I will act with fairness towards all parties involved in the inquiry process. I'd now like to invite Mr. Stuart Gale KC to make some opening remarks.
Thank you, my Lord. Good morning, everybody. Can I also thank everyone present here in Murrayfield and also watching us online for joining us today in what is the first preliminary hearing of this inquiry, and indeed a very important milestone in the inquiry. As some of you may know, I'm Stuart Gale, King's Counsel, and together with my colleague Laura Ann van der Westhuizen, King's Counsel, we are the co-lead counsel to this inquiry. Our responsibilities so far as the investigative work of the inquiry and indeed the presentation of the evidence are divided between us and our respective teams. You will be aware, perhaps from the inquiry's website, that we have structured our investigative work into 4 portfolios. My team and I are responsible for portfolios 1, which is the public sector response, and portfolio 3, which is of specific significance today, that is the provision of health and social care services. Ms. van der Westhuizen and her team are responsible for portfolios 2, which is the financial and welfare support to businesses and individuals, and Portfolio 4, which is education, certification, and impact on children and young people. My council team comprises advocates Alan Caskey, who is here with us today, and Farima Barami. Ms. van der Westhuizen's team comprises advocates David Turner and Mary Ellen Stewart. In addition, our council teams have further council input from advocates Chris Stevens, Dennis Edwards, Graham Dunlop, and Sarah Traynor. Each council team works with a dedicated team of solicitors and paralegals and support staff. Various specific investigative streams have been and will continue to be allocated to various members of the council and solicitors teams. In these introductory remarks from me, I would like to reflect, if I may, on some of the matters touched on by Lord Brailsford in his opening remarks. At the very outset, Lord Brailsford mentioned the honour that his appointment represents and the appreciation of the nature and extent of the undertaking which lies before him. None of us associated with this inquiry is under any misapprehension as to the scale of the task before us. It is immense, and to a certain extent it is daunting. Speaking personally and on behalf of the whole council team, we are all honoured by the fact that Lord Brailsford has placed his trust in our abilities to perform the roles of counsel to the inquiry. Our role in the inquiry is to be independent and to perform our duties to the best of our professional abilities. And we do that, as Lord Brailsford has said, in the general context of the inquiry, without fear or favour. All of us intend to carry out our duties in that way. Now, both Lord Brailsford and I have had the honour of meeting members of both the Scottish COVID bereaved and Care Home Relatives Scotland. In those meetings, we heard distressing accounts of the loss of loved ones, the circumstances experienced both before and after that loss, and the impacts of being separated from loved ones, particularly in circumstances where that loved one had a compromised understanding of the reasons for that separation or isolation. To all those relatives, and indeed to those individuals, whether in care homes or in other settings, the council team, through me, conveys their deepest condolences and sympathies. Most of us have experienced personal loss, whether it be of a loved one, a family member, a dear friend. The circumstances attending such loss are inevitably difficult to deal with. To try to have to cope with the circumstances of loss in the overall context of the restrictions imposed by outside authorities, all in the context of a pandemic, are completely unparalleled. In addition to those who tragically died during the pandemic, and those who had to deal with the impact of the pandemic and its restrictions in visiting loved ones in care homes and other settings, we as a council team are mindful also of the impact that the pandemic had on workers in the healthcare sector in particular, and those impacts are relevant to our investigations. Indeed, if I may be permitted to make a personal observation, having watched now for I think the third or fourth time the film that we've just seen, there was a quotation from a nurse in that film, and she said this: "Feeling we were failing everyone bore down hard on us as nurses. Our best was rarely good enough." And that was then followed by a photograph of a trainee advanced critical care practitioner in full PPE with bloodshot eyes. That was a particularly moving reminder of the impact that caring for people during the pandemic had on those in the caring professions. Lord Brailsford has said that the role of this inquiry is to establish the facts of and learn lessons from the strategic decisions taken in response to COVID-19. Establishing the facts and the critical examination of those facts will lead to recommendations, the intention of which will be to provide an informed basis for an approach to dealing with another pandemic should one occur. As a council team, we are committed to the establishment of those facts and to a critical examination so that lessons can be learned. We will not hold back in examining and stating anything we consider to have been mistakes in the strategic decision-making process. Some chairs of previous inquiries have been sceptical of the success that inquiries have achieved in providing the basis for different approaches to similar circumstances. Let me give one example. Dame Janet Smith, who chaired the shipment inquiry, said this, quote, "If the success of public inquiries is judged in terms of changes in regulations and legislation, then we cannot often claim to have achieved that." Now, we are aware of that critical approach, and we are determined that this inquiry will be a success in providing recommendations to decision makers so that they are better prepared in the event of a future pandemic. And in saying all this, we are mindful as an inquiry that COVID-19 remains in Scotland, as well as in the UK more widely, an issue. The National Records of Scotland for the week to the 13th of August of this year disclose that 17 deaths were recorded during that time in which COVID-19 was mentioned, and that there have been also recent media reports of new variants emerging and new mutations. More recently, Professor Jason Leach, the National Clinical Director, stated in an interview last week that 200 people were admitted to hospital with the virus in the previous week. Also, over the weekend, we have been aware of further press reports regarding the closure of certain hospital wards due to the presence of COVID and again also of further mutations. It seems reasonable to assume that COVID-19 is not behind us, and we therefore take extremely seriously our obligation to identify the lessons to be learned from the pandemic that we have just been through. Can I now pass back to Lord Brailsford to provide an update on the progress of the inquiry so far?
Thank you very much indeed, Mr. Gale. Now, in this section, we will provide updates in a number of areas, including staffing and premises, planning and structure of the inquiry, the approach the inquiry will take in terms of human rights, being person-centred and trauma-informed, connections with the UK inquiry, in with the Crown Office and Procurator Fiscal Service and gathering evidence. I should say that we will, between myself and Mr. Gale, we'll share the informing you about these various heads, under these various heads. So I will start with staffing. Over the last few months, the inquiry has undertaken a number of recruitment exercises to further expand the team to conduct the investigation. That process is advanced with new team members now in post or joining soon. In July, I welcomed Mr. Ian Duddy to the inquiry as Chief Executive, and you heard very briefly from Mr. Duddy earlier this morning. As Chief Executive, Mr. Duddy is the inquiry's most senior official and will be responsible and accountable for the administration and management of the inquiry. He brings to the inquiry more than 20 years' experience in leadership, advocacy and human rights, having served as a senior diplomat, UK ambassador and former chair of the Scottish Human Rights Commission. I am confident that Mr. Duddy's extensive leadership experience will ensure the inquiry continues to proceed apace. He will also be instrumental in assisting me in upholding my commitment to conducting a robust, independent investigation and adopting a human rights-based approach in arriving at its findings and recommendations. As some of those present today will be aware, the secondment of Miss Joanna Bain, the inquiry's interim solicitor, will end on Thursday 31st August, 3 days' time. I would like to thank Miss Bain for her significant contribution to the inquiry to date and wish her well with all her future endeavours. I am happy to announce her successor as interim solicitor is Mr. Gordon McNichol, who is sitting on my left, although he's probably quite hidden from you, I fear. Mr. McNichol is an experienced solicitor who brings with him experience of working on other independent public inquiries. Mr. McNichol has already taken up post and is with us here today, as I've already said. Recruitment for the permanent appointment to this post is ongoing. I will ensure core participants are informed once this recruitment exercise has concluded. If I now turn to premises, we have been working in our offices at Waverley Gate at the end of Princes Street for most of this year. The space the inquiry team is using currently will become our hearing suite, and we will move to another office space within the same building. The refurbishment works to make the hearing space suitable and accessible will be completed in summer 2024. We are therefore planning to use other buildings for our hearings scheduled before then. We will use the land court space at George House in central Edinburgh for our first impact hearings in October, and Mr. Gale will say more about this shortly. We recognise that those giving evidence may wish to have family members or friends close by, and that we may not be able to accommodate everyone in the hearing room at George House. We are putting the needs of families and the bereaved very much at the forefront of our consideration of suitable spaces to hold hearings. Therefore, we are hiring additional space close to George House where the proceedings will be live streamed and families and friends can watch and have access to refreshments. We will have a hearings and witness support team in place for those hearings and will ensure that appropriate emotional support is available to those who need it, both in the hearing space and in the additional room where the live stream will be shown. A named support officer will be available for those giving evidence prior to their attendance on the day. The support officer will ensure those giving evidence know what to expect when they attend, have the opportunity to visit the hearing space beforehand, and receive support on the day. The support officer can also provide signposting to organisations that may be able to help to provide bespoke or ongoing support if that is required. This forms part of our person-centred and trauma-informed approach, and I will say a little more about that later today. I'd now like to pass back to Mr. Gale to tell you something about the planning and designing of the structure of the inquiry.
Thank you again, my Lord. I would like now to share with you information about our structure and approach that we propose to take with our investigations and hearings. And again, this is in the context of the health and social care hearings that are upcoming. The inquiry is adopting a thematic approach. The themes are health and social care, education and young people, and finance, business and welfare. For each of these themes, the inquiry will look at the impact of the pandemic first, then the implementation of measures, and finally key decision making. Our approach seeks to bring the experiences of people in Scotland to the forefront of the inquiry's investigations and the presentation of evidence, ensuring that the human impact of the pandemic is captured first. This is a deliberate choice on our part, and I consider it right at this stage I should explain a little more detail about the reasoning behind that choice. Last year, the council team gave advice to His Lordship as to how we saw the order of consideration in this inquiry. In giving that advice, our view was that impacts were likely to have been contingent upon the decisions that were implemented. In essence, decisions have consequences. The fact and existence of decisions and their implementation gave rise to the impacts. It was our view that it would not be possible to consider decision-making without first considering the impacts. As further consideration was given to that approach, we became more satisfied that consideration of impacts should precede consideration of implementation and decision-making. In simple terms, we considered that in order to properly consider the quality and nature of the decisions made and the way in which they were implemented, the inquiry first needs to consider the impact of those decisions in the real world. The council team made this recommendation to Lord Brailsford, and after discussion with him, he accepted the recommendation. Thereafter, the approach was further refined. In particular, it was decided that the examination of impacts should begin with the impacts in the health and social care setting, and that we should conduct detailed examinations of those impacts. I should emphasize that the council team was not persuaded by the suggestion that impacts did not require detailed consideration on the basis that those impacts were obvious. I can perhaps give an example of the subtlety of certain impacts that would not, in my view, be regarded as obvious. Recently, I have seen one witness statement where the individual who gave it had certain vulnerabilities, and they indicated that some of the advice created in their mind a level of fear which had an adverse impact on their confidence and affected their coping mechanisms that they had come to rely on in dealing with their vulnerabilities. There were a number of reasons we made a positive decision to commence our impact hearings with those in the health and social care setting. As Lord Brailsford will explain, the inquiry has adopted a trauma-informed and human rights-based approach to our investigations and our hearings. And with that in mind, we considered it appropriate that in our evidential public hearings, we begin without delay consideration of those people who wish to engage with the inquiry and who have suffered loss and or trauma of separation from loved ones. We are also minded that much of the evidence from such witnesses will depend on personal recollections without the aid of extensive contemporaneous written records, and with that in mind, we feel that we should bring this evidence to the fore. A further consideration that we have in mind is that while our principal role is information gathering, we appreciate that for many involved in public inquiries, providing a public statement, whether that is simply the statement or one which is then expanded upon at an oral hearing, is a cathartic experience, and we are anxious to provide that opportunity. Now, it is right now that I give an indication of our program of impact hearings in the health and social care setting. The Chair has to strike a balance between the need to report as quickly as practicable so that lessons can be learned, and ensuring that the inquiry conducts a robust, open, and independent investigation which gets to the truth and makes recommendations grounded in evidence and informed by the experiences of the people of Scotland. In addition, he has a statutory duty to act fairly and with regard to the need to avoid unnecessary cost. By necessity, this means the inquiry will not be able to hear from everybody who wishes to give a formal witness statement or provide formal oral evidence at an inquiry, at a hearing. To do so would lead to unacceptable delay in terms of reporting on findings and making recommendations. However, we will invite a number of organisations and individuals to appear as witnesses at our impact hearings. Those organisations and individuals will also provide signed witness statements, which will be published on the inquiry website and will form the basis for Council's questioning of witnesses. The impact hearings will begin on Tuesday, the 24th of October of this year. Weekly sittings will be from Tuesday to Friday of each week. The hearing will start at 10 a.m., continue through to about 11:30 for a mid-morning break, resume thereafter until 1 o'clock. We will then resume after lunch at 2 o'clock and continue until 4 o'clock or thereby, with a short mid-afternoon break. There will be flexibility in these timings, and particularly about the finishing time, if it is necessary to complete the evidence of a witness. It is my intention that we begin with what we are terming representative statements on impacts. These will be from representatives of organisations speaking to the sorts of impacts that people associated with their organisations experienced. The organisations will include those which were established during or just after the pandemic, as well as from organisations which were established before the pandemic and continue to operate during it. In this regard, the inquiry has been in contact with a number of charitable organisations, as well as other organisations established to assist with those having particular needs. The decision to take such evidence was instigated after certain members of the council team, including myself, held meetings with a number of organisations, and they provided anecdotal information in respect of groups that they had supported during the pandemic. From the third week of hearings, we anticipate that those representative hearings will probably take 2 weeks. From the third week of hearings, I expect to commence hearing from members of Care Home Relative Scotland and Scottish COVID bereaved. And we are grateful as a council team and as an inquiry generally to Mr. Maguire, Mr. Anwar and their teams for facilitating engagement with members of the client groups that they represent. Further, we are grateful to members of those groups who have already provided witness statements, and to those who are making time to engage with the inquiry team to allow further statements to be taken. As has been made clear, not all members of those groups will be called to give oral evidence, and the decision as to who gives oral evidence will be one for me and my team. But I can assure you that we will try to ensure that a broad range of impacts arising from this tragic situation are presented in oral evidence, and I would wish to emphasize that all statements given by members of those groups, and this applies to all groups and all others who provide statements, will be considered and account will be taken of them. It had originally been my intention in these initial hearings to only take evidence from those who suffered bereavement in the care home setting. On further reflection, it seemed to me that to do so would be an unnecessary division, and that mindful of the distress giving evidence of bereavement will inevitably cause, I have concluded that witnesses from these groups will give evidence of deaths of loved ones experienced in all settings. I do not intend to place a limit on the length of time that witnesses from either group, or indeed any other witnesses, will take, and with the scheduling of all witnesses to the inquiry, there is no case of preference or prioritization being given. The inquiry intends to complete this first tranche of impacts hearings at the conclusion of the week ending Friday the 8th of December. We want to finish before the festive period, as we appreciate that for many people who have been impacted by the pandemic, this will have been and will continue to be a very difficult period. Therefore, we will continue our engagement with the Care Home Relatives Scotland and the Scottish COVID bereaved and their legal representatives, beginning as it has already and will continue, with a view to completing the witness statement taking process. And I should say that last week we were very grateful to have been provided by Mr. Anwar and his team of a total of 66 statements from members of the Scottish COVID bereaved group. And we are in the process of examining those statements, reviewing them, analysing them, and if necessary, seeking further clarification in certain areas. For those individuals who are asked to provide oral evidence at the impact hearing, the inquiry team will explore their availability in order to inform scheduling of the witness timetable. This is all with the ambition of having called all relevant witnesses in this area by the 8th of December, subject obviously to availability. The inquiry obviously has an idea of the number of witnesses who are likely to give evidence. We have a very clear idea of that in these groups, and also in the representative organisations that I've referred to. It seems to us that given the anticipated numbers of witnesses, it is quite possible that the witnesses from these groups will occupy the entire period to the 8th of December. Thereafter, we will continue with our investigations, and I should say that our investigations do not stop during the presentation of evidence. Our investigations are ongoing as they have been now for many, many months. But we will continue with our investigations, but we will not hold further public hearings until February 2024, so that we do not overlap with the UK inquiry's Module 2A hearings, which are on Scottish matters and which will be held in Scotland. From February, we expect to run until Easter, continuing with public hearings on health and social care impacts. The reason that we are not being specific at this stage about the exact number of weeks or the witnesses at this point is that we are mindful that many of the witnesses we call will have suffered bereavement or loss, and we wish again to make a trauma-informed approach to all these hearings, not rushing witnesses to get through to a fixed timetable. Our intention for the remainder of 2024 is to hold hearings on the impacts on education and young people, and after that on the impacts, both human and economic, on finance, business and welfare. And these obviously, as I've said earlier, fall within the portfolios that are headed by my colleague Laura Ann van der Westhuizen. We will then return to health and social care and hold hearings on implementation, hearing from those who took decisions to put into practice the legislation and guidance in the health and social care sector over the period that we are investigating. Now, can I ask Lord Brailsford now to expand on the approach of trauma-informed and human rights?
Thank you again, Mr. Gale. Now, the trauma-informed approach we are taking with respect of health and social care impact hearings will be embedded in all the inquiry's work. While our purpose and terms of reference are set by Scottish ministers, it is for me, as chair of the inquiry, to set out how we will engage with others, how we will organise ourselves, and how we will deliver these outcomes. I want to ensure that every person and organisation engaging with the inquiry feels they have been treated fairly and feels that they have been heard. I know that many of the people the inquiry will be engaging with have suffered loss of different kinds. Everyone working in the inquiry has had training in trauma awareness. Those colleagues working in direct contact with individuals who have been bereaved or suffered other losses have had specific, more in-depth training, so they are equipped with the skills they need to conduct their tasks. While it is not the role of a public inquiry to provide counselling, we will provide emotional support at hearings through our own team and, where appropriate, through partner agencies. When reporting at the end of the inquiry, I am required, quotes, to demonstrate how a human rights-based approach by the inquiry has contributed to the inquiry's findings in facts and recommendations, close quotes. This means taking a human rights-based approach from the beginning. I want to set out here how I intend to do that. A human rights-based approach goes beyond a series of specific actions. I view it as the philosophy of the inquiry and embedded in our approach to how we conduct our work in accordance with the terms of reference. We will apply this philosophy when scrutinising the extent to which decision makers and those implementing measures set out in legislation and guidance had regard to human rights considerations. When investigating the 12 areas in our terms of reference, we will consider ways in which the strategic handling of the pandemic may have had an adverse effect on the exercise of human rights. As measures varied over time, we will consider developments of legislation, guidance and policies individually and cumulatively, and the extent to which regard was given to human rights and equalities duties. It is important to remember that my role is not to determine if rights have been breached in individual cases or circumstances. However, when the inquiry makes findings about lessons learned, where I determine it is relevant, I will consider and comment on any adverse effects on the exercise of human rights or equality issues. On the issue of equalities and any disparities or unequal impacts, I am bound in the terms of reference to consider these as I deem appropriate and necessary. A statement of how we will embed a human rights-based approach in our work will be published on our website in advance of our October hearings. I'd like now to turn to our relationship with the UK inquiry. I recognise that people living in Scotland may be affected by, and indeed interested in, the investigations of both the Scottish COVID-19 inquiry and the UK COVID-19 inquiry. The response to the COVID-19 pandemic involved both Scottish and UK authorities. This inquiry will only investigate areas within the devolved competence of the Scottish Parliament. However, as chair, I recognise the importance of it being clear to people which inquiry is responsible for looking at particular issues, and both inquiries have an obligation in our terms of reference to take steps to minimise any duplication of evidence gathering, investigation and reporting. I have had several discussions with Baroness Heather Hallett, chair of the UK COVID-19 inquiry, about how our two inquiries might work together to share information and maximise value for money to the public purse. In February this year, we signed a Memorandum of Understanding which formalises our agreement. This commits us to providing clear information to the public about how each inquiry will conduct its investigations in Scotland to enhance public understanding of its work, including both public engagement exercises, Let's Be Heard, and Every Story Matters. Officials and solicitors meet regularly and share information and planning where possible on areas which are within both our terms of reference. While we do not share evidence directly with each other, we endeavour to minimise the burden on material providers by sharing our requests for information so that where such requests meet each other's needs, these are identical and require one search rather than two. Earlier in the summer, we held a meeting for organisations which are co-participants in both inquiries. This was found useful by all parties and is something we will be pleased to arrange again at suitable points in time. Where possible, we will organise our timetabling of hearings to ensure we do not hold public hearings at the same time as each other. However, we are mindful of our own responsibilities in conducting our separate independent inquiries. I need to consider the interests of those who are not part of the UK inquiry and who deserve to see this inquiry's progress in a reasonable timescale. It will not be possible, or desirable therefore, to avoid having public hearings which overlap at times. After the festive period, when the UK is holding its Module 2A hearing, which is specifically about Scottish matters, we will pause our own hearings. However, neither inquiry can guarantee there will not be overlapping hearing schedules at other times when the focus of the UK inquiry hearings is not Scotland specific. Our particular meetings with our UK inquiry counterparts will assist us in planning this, and both inquiries will be flexible in responding to situations where the same witness or witnesses may be scheduled for a particular set of hearings. I now ask Mr. Gale to again represent you in relation to the relationship with the Crown Office.
Thank you again, my Lord. In the same way in which we and the UK inquiry respect each other's independence, we and the Crown Office and the Procurator Fiscal Service respect the distinct and independent roles each has. The inquiry is aware of the investigations being carried out by Crown Office into deaths which occurred in care and nursing homes and other settings during the pandemic, and the importance of avoiding wherever we can the possibility that work carried out by the inquiry prejudices those investigations or any subsequent proceedings. The inquiry and the Crown Office have already established an ongoing dialogue relating to these matters and will continue a channel of communication concerning their respective work, and the inquiry will discuss with all legal representatives of core participants and others in the event that we consider that it may be appropriate or necessary to defer participation in the inquiry to a later date.
Thank you again, Mr. Gale. Now, an update on evidence gathering. Using my powers under the Inquiries Act 2005, I have required public bodies, including the Scottish Government, to produce documents relevant to the inquiry's investigations. We estimate that during the course of this inquiry, we will review and analyse millions of such documents with the aim of producing a factual record of the key strategic elements of the handling of the pandemic. Rule 8 and Section 21 notices are the two avenues at the inquiry's disposal to pursue to recover documents and evidence from individuals and organisations. A Section 21 notice gives the chair of the inquiry the power to compel an individual or organisation to hand over documents and evidence to the inquiry. In contrast, a Rule 8 request is for the voluntary provision of records and evidence. The inquiry has published a full list of the recipients of Rule 8 and Section 21 recipients on our website. When embarking on its evidence gathering process, the inquiry was mindful that information relevant to its investigations may include communications shared via WhatsApp and other private messaging applications. To ensure that such material is not lost or destroyed, in August 2022, the inquiry issued Do Not Destroy letters to organisations and individuals which may hold information relevant to the inquiry's investigations. Those letters, which made specific reference to WhatsApp and text messages, emails and other communications, require such information to be preserved and retained so it is available to the inquiry as and when required. The inquiry is examining all the material that has been provided to it by Scottish Government and other parties. As this process continues, I will decide whether any further calls for evidence are required. Where documents or requests for information are required for these hearings, we will endeavour to engage as early as possible with document holders to understand demands on organisations and coordinate requests for evidence where practicable. While I do not have power to make any findings of criminal or civil liability, I will continue to use my powers as chair to the inquiry to obtain evidence and to compel the production of documents and the appearance of witnesses. I will not tolerate any attempt to obstruct or hinder the work of this inquiry. And can I now ask Mr. Gale to tell you something about Let's Be Heard?
Thank you again. Earlier it was mentioned today that you do not have to be a core participant to engage with the inquiry. For most people in Scotland, the principal channel for sharing your experiences with us is through our listening project, Let's Be Heard. It aims to give a voice to as many people in Scotland as possible. Let's Be Heard allows people to tell us about their experiences in the pandemic, how these affected them, and any lessons that they believed should be learned or could be learned from those experiences. We are gathering and analysing the thousands of experiences the people of Scotland have kindly shared with us through Let's Be Heard. Provision of information to Let's Be Heard is a formal submission to the inquiry. Therefore, project staff are working closely with the inquiry's legal teams in engaging with both organisations and individuals. In addition to facilitating the identification of potential witnesses, the experiences gathered through Let's Be Heard will help guide the inquiry's investigations and inform its reports and recommendations. And I can perhaps just reiterate that the quotations that you saw on the film that was played this morning were in the main obtained from representations and communications received by Let's Be Heard. The process that we are undertaking will include identifying any disproportionate or unequal impacts on particular groups or communities. The legal team review the evidence received by Let's Be Heard and may follow up with individuals to ask if they would provide a further statement to the inquiry. In addition to our online platform and paper forms, Let's Be Heard has created a bespoke engagement guide to encourage organisations to engage with their members in a way that best suits them. Let's Be Heard asks to attend events where invited and offers financial support to help meet accessibility needs. Let's Be Heard is also designed with accessibility in mind, but we understand that some may face further barriers in participation. We encourage people to contact Let's Be Heard if they have any queries or require any additional materials, any translations, languages, or formats, so that they can find a way for people to engage with Let's Be Heard. A dedicated team of researchers and analysts has been recruited to the inquiry to analyse these responses. And Let's Be Heard will publish a series of reports based on key findings of the experiences shared by the public in Scotland. The reports will provide insights into the issues, impacts, and recurring or emerging themes. So far, Let's Be Heard has received 2,800 responses from individuals and groups and will continue its national engagement approach until the end of this year. I'm grateful to the team for providing detailed information with regards to the geographic spread of the responses into Let's Be Heard. It is pleasing that Let's Be Heard has received individual responses from people in every local authority area in Scotland. Based on a preliminary analysis of submissions, it is perhaps, however, unsurprising that almost a quarter of all responses have come from the City of Glasgow and the City of Edinburgh areas. Certain areas that we have heard less from include, for example, West Lothian, North Lanarkshire, and Fife. And I would welcome as many people as possible from those areas and indeed across Scotland broadly to engage with Let's Be Heard. Frankly, we all have an experience that can be conveyed to us. Both Let's Be Heard and the Council team are eager to ensure that we hear from ethnic minority groups in Scotland. And I would use this platform to ask that members of such groups engage with the inquiry, either directly or through Let's Be Heard, in order that we are informed of the impact of the pandemic on members of such groups and their suggestions or any lessons to be learned so that they can be incorporated into our investigations and final recommendations. Let's Be Heard will undertake a more targeted approach this winter and beyond, which will include more specific engagement and research, such as focus groups and workshops as requested by the inquiry's investigative teams, in order that we can fulfill any information gaps and provide a more detailed information base. Allied to this, I wonder if I could refer briefly to academic research that the inquiry has instructed and undertaken. So we have been able to call on independent academic research of the highest quality. When the inquiry was established in December 2021, it commissioned introductory scoping research from academics considered to be leading authorities in their respective fields to provide context for the inquiry's investigative portfolios. This research has been crucial in helping direct our investigations and covers many, but not all, of the areas within the inquiry's terms of reference and form a multitude of perspectives. In keeping with the transparent way in which we are working, these scoping research reports were published on our website in June 2022 and included research from academic institutions, including the universities of Dundee, Edinburgh, Napier, Glasgow, Highlands and Islands, and Birmingham. These reports covered the period up to April 2022. We issued a second call for academic research in January of this year to extend that scope of research to cover the entire period of the inquiry, that is up until the 31st of December of 2022, as well as additional areas identified as important. We are preparing to publish these additional reports on our website in the coming weeks and months. I have found the high-quality research which has been produced to date to be extremely instructive as we conduct our investigations and prepare for our public hearings. And I'm very grateful to all the academics involved for their continued invaluable input into our work. This research is one of many sources of evidence of the inquiry, and which we will consider before we report. And it follows, therefore, that the content of the research we have received and will receive in future should not in any way be seen to preempt the eventual conclusions and recommendations that we will make. Could I also say some words about the science and epidemiology? As COVID-19 spread across the world, we all found ourselves in uncharted territory. Decisions regarding Scotland's response to the emerging pandemic were taken against the backdrop of evolving science regarding the nature and transmission of COVID-19 and the race to develop and then roll out effective vaccines. In July of this year, Dr. Ashley Croft provided a report and a presentation on the epidemiology of COVID-19. We will be hearing from other epidemiologists and public health experts as we continue our investigations. In addition, we will be analysing academic research and materials published by a wide range of sources including those commissioned by the UK inquiry, where relevant to our terms of reference. None of the findings of these expert reports and academic research papers is binding on the inquiry, which will reach its own conclusions on all matters within the terms of reference. We will also be examining the science which informed the alternative strategic approaches taken by countries around the world to managing the pandemic. We will explore what factors influenced the contrasting approaches taken by countries such as New Zealand and Sweden, and how these compare to the decisions taken in Scotland. And now back to Lord Brailsford on the matter of reporting.
Although I think we will have a pause. Thank you very much, Mr. Gale. That has been a relatively large amount of information, and I appreciate you've all been very patient over the course of almost an hour and a half. And I also don't forget, of course, that much of this for many of you has been quite emotional. So we'll have a break now of about 15 minutes or thereby, which should have us back. My computer has conveniently switched itself off, as these things do at the moment, so I'm not sure of the exact time. I think it's about 11:20, so round about 25 to or 20 to 12. Very good. Thank you all very much. We'll pause for a moment.
like bellow and voice out to the door.
Well, you see me losing my temper, haven't you? Good, thank you.
It's not very common,
No, it's not. Good. Right. Welcome back. Now, I think I said just before the break that I would turn now to reporting. It's not possible for me to say at this stage how long the inquiry will take to reach its final conclusions. But we will, of course, report as quickly as we can, whilst ensuring we conduct a robust, thorough, independent investigation which establishes the facts and identifies any lessons that need to be learned so that Scotland is better prepared for the future. As the work of the inquiry progresses, it is my intention to publish interim reports as and when I consider it to be appropriate to make sure interested parties are kept informed. Again, I can't say how many we will have. It will very much depend on when it seems appropriate to do that. I turn now to specific protocols which are probably of primary interest to those that will be solicitors who will be responsible for looking after the affairs of their clients in a practical sense. So I'm going to deal with protocols and orders. Firstly, restriction orders. A number of questions have been put to the inquiry in advance of today's proceedings relative to anonymity, disclosure, and use of identifying information. As chair, I have been clear that I consider it important that this inquiry carries out its work in as open and transparent a manner as is possible, and that its proceedings are conducted in public. However, I appreciate that there will be circumstances where it would not be appropriate to do so, and that it will be necessary and in the public interest to keep some of the evidence provided to the inquiry private. One of the powers available to me as chair is the power to make an order known as a restriction order, which restricts the disclosure or publication of specific information. These orders remain in force unless and until I decide they should be changed or cancelled, and usually remain in force at least until the inquiry has ended, but often beyond that. I made one of these restriction orders on 5th of May this year, known as Restriction Order 1, Health and Social Care. The effect of that order is to impose restrictions on the publication or disclosure of evidence or documents produced by or provided to the inquiry pertaining to health and social care in the inquiry's investigation of matters covered by terms of reference G, H and I, and where appropriate, terms of reference C, D, E and F. It is important to note that this order applies equally to the inquiry itself as it does to co-participants. The inquiry is very grateful to individuals who are coming forward to provide witness evidence and is acutely conscious of the need to ensure sensitive information is given appropriate protection. In terms of how Restriction Order 1 works in practice, it first creates a category of protected persons who will benefit from the protections set out in the order. Those are persons who apply to give evidence to the inquiry in respect of the inquiry's impact hearings on health and social care, that person's family members, persons and/or their family members who were in receipt of care in a residential care setting or hospital, or in receipt of health and social care in the community, alongside the witness. The name of the residential care setting, hospital or other care setting, the name of individual carers, whether paid or unpaid, and healthcare providers. A person who is a key worker, although this is subject to certain exceptions. Restriction Order 1 prohibits the disclosure or publication of information that can enable a protected person to be identified unless I give my express written permission to the contrary. What this means in practice is that careful consideration will be given before documentation is disclosed by the inquiry in unredacted form to ensure that the information falling within the terms of the restriction order is kept private. There are exceptions to the restriction order. For example, where we receive evidence which includes allegations of criminality, the inquiry may disclose the identities of a protected person to Police Scotland. Therefore, I would encourage all core participants to ensure their legal representatives have reviewed Restriction Order 1. It can be found on the inquiry's website. I also want to remind core participants of the terms of Section 36 of the Inquiries Act 2005. This provides that where a person fails to comply with or breaches a restriction order made by the inquiry, I may refer the matter to the Court of Session. Any breach of the restriction order will not be treated lightly, and I request in the strongest terms that all legal representatives and core participants ensure they are familiar with its terms. I'd like to say something now about anonymity. I am aware that there may be circumstances where individuals may wish to provide evidence to the inquiry but may be concerned about any personal or professional implications of them doing so. Therefore, I wanted to address today the matter of whether an individual can provide a statement to the inquiry anonymously. I consider that anonymity for those providing evidence to the inquiry will only be granted if the reasons why it is required have been properly justified. This would be done on a case-by-case basis and would involve the individual or their legal representative setting out in writing why it is needed and who should be covered by it, and that will enable me to make a decision on that matter. Criticism. Some core participants have raised questions with me about whether they will have the opportunity to respond to any criticisms made about them by witnesses to the inquiry. I would like to highlight Section 10, subsections A, B and C of Restriction Order 1, which enables the inquiry to disclose the identity of protected persons to individual carers or healthcare providers or residential care settings or hospitals or other care settings and their representatives in the interest of fairness. In practice, what this means is that where significant or explicit criticism of individuals or organisations is made, the inquiry can disclose this to them in the interests of fairness. As with our approach to granting requests for anonymity, the inquiry will take decisions about whether to disclose such information on a case-by-case basis. In the event that an unexpected criticism is made during the course of a hearing, the live stream will be on a delay, which will give the inquiry time to prevent that information from being released into the public domain. The terms of the restriction order will apply to all those in attendance at the hearing. While organisations are entitled to respond to criticisms made of them, the inquiry cannot guarantee the opportunity to respond before a witness gives evidence, nor will the inquiry give a right of reply. Organisations will have opportunity during the course of the implementation hearings to provide statements in which they can comment on the evidence presented to date. The inquiry is an inquisitorial process, not an adversarial one. Therefore, depending on the severity of the criticism and the implications this might have for an organisation, I may decide that details of the criticism will not be disclosed to the wider core participant group. I have also been asked to clarify whether the inquiry will investigate and rule on every criticism and complaint. It is not the role of the inquiry, and therefore we will not do so. Now, leave to appear. Whilst this does not apply to preliminary hearings such as the one we are having today, there will be a general rule at all substantive hearings that any core participant who wish to appear at this inquiry's hearings will be required to be granted leave to appear. I think I may have said leave to appeal by mistake at the outset of this. I apologise for that. It's leave to appear. Those granted leave to appear at any hearing in the inquiry will, be given copies of documents to be referred to at the hearing prior to those being made available to the public in advance of the hearing taking place. Be able to request counsel to the inquiry to ask certain questions of witnesses. To be able to ask questions of witnesses direct with the permission of the chair, and be able to make opening submissions at the hearing where the chair directs that such submissions are required. Making a closing statement at any hearing where the chair directs the making of such statements is not contingent on the co-participant or their recognised legal representative having had leave to attend the hearing to which the closing statement relates. Those granted leave to appear will be notified of the number of representatives they can have present in the hearing room during the hearing in question. I would remind co-participants that the requirement to obtain leave to appear applies separately to each substantive hearing date held by the inquiry. So leave to appear at one hearing does not confer leave to appear for any subsequent hearing. I encourage co-participants and their legal representatives to familiarise themselves with the terms of the inquiry's leave to appear protocol, which can be found on our website. Opening statements. In relation to the October 2023 impact hearing, I can confirm that opening statements will be sought from co-participants who have been granted leave to appear. I will issue a direction on opening statements in due course, which will set out my position on this matter. Expenses. I recognise that the question of the payment of expenses has been raised in advance of this hearing. As chair, I have a legal duty to minimise expense to the public purse. The inquiry's current policy of not paying travel expenses to people voluntarily attending a hearing in person is consistent with those of other public inquiries. The inquiry does, however, pay legal expenses for co-participants and others, where eligible, to ensure they have appropriate legal representation throughout the course of the inquiry's work. We will shortly publish our policy with regards to the payment of expenses for witnesses who will be asked to attend future hearings. People who are unable to attend the inquiry's preliminary hearing and future hearings are invited to watch them via dedicated live streams on the inquiry's YouTube channel, which will also be recorded and available to watch anytime on demand. The questioning of witnesses. In advance of our first substantive hearings, I wanted to take some time to set out this inquiry's position regarding the questioning of witnesses. Excuse me a second. Rule 9 of the inquiry's Scotland Rules 2007 enables core participants to apply to examine a witness. Witnesses may be asked to give evidence in the form of a written or oral statement and may also be asked to appear at an inquiry. I will issue a procedural direction in the coming weeks which will set out further details on the process for co-participants making an application to pose questions. My intention is for inquiry counsel to ask any questions that have been posed by co-participants, subject to them being granted permission by inquiry counsel, rather than have witnesses examined by the representatives of co-participants. I would expect that application process to be preceded by an informal approach to counsel to the inquiry to explore whether they are prepared to put a question or line during examination. Confidentiality undertakings. I wish to highlight that confidentiality undertakings were sent to co-participants on 24th August 2023. I remind all co-participants and their representatives that documentation will only be disclosed to individuals who have signed such an undertaking. Evidence and witnesses. For our October hearings, core participants who have status in respect of sections G, H and I of the inquiry's terms of reference and leave to appear will receive bundles containing witness statements and documentary productions in respect of this tranche of hearings prior to these being available to the public and in advance of the commencement of the October 2023 impact hearing. The inquiry team is working towards an initial tranche of disclosure in respect of bundles at the end of September 2023. Documents will be shared with core participants using our document management system, Relativity. The inquiry is in the course of gathering evidence from a variety of sources in preparation for the first set of hearings. As I highlighted earlier in the session, in the context of the impact hearings specifically, written statements are being sought from members of core participant groups and relevant external organisations, in addition to which we are conducting detailed analysis of the submissions made to Let's Be Heard. Core participants will not be entitled to comment on draft witness statements of others. The only circumstances where someone may comment on a draft witness statement is the witness to whom the draft pertains. Inquiry Counsel will then take a view on who ought to be called to appear in person to give oral testimony. As a general statement, witnesses who are called to give oral evidence will, at the start of their evidence, be invited by counsel to the inquiry to confirm that they will adopt the written statement as their evidence. The inquiry team will identify and call witnesses to give evidence. We will, of course, communicate to core participants when their own members are expected to be called, but it is not our intention to publish a witness list for impact hearings. However, we will provide, on a weekly basis, a list of those with leave to appear in that period. Because of the nature of impact hearings, there may require to be changes to the intended witness schedule. Witnesses may be asked to give evidence in the form of a written or oral statement and may also be asked to appear at an inquiry hearing. Counsel to the inquiry will identify and call witnesses to give evidence. Witnesses who speak to key and distinct impacts will be invited to give oral evidence. Evidence will be led by a cross-section of witnesses who are able to speak to key and divergent impacts experienced by individuals. Can I turn to access to medical records? Specific questions have been asked in advance of this hearing about whether the inquiry plans to routinely consider the medical records of individuals who have been asked to give evidence. Given the inquiry's remit, it is not our function to ascertain causation of anyone being in hospital. Therefore, it is unlikely. They will only be requested as and when required. Where the inquiry does require access to a patient's medical records, it will issue a notice under Section 21 of the Inquiries Act 2005 requiring their production. The inquiry may involve medically qualified persons in considering patient records if it considers it necessary. I will make decisions on what records may be relevant, and I will consider this on a case-by-case basis, bearing in mind what is necessary, proportionate, reasonable, and relevant to fulfil the inquiry's terms of reference. Not everything that is collected will be disclosed to core participants or placed into the public domain. This will also be considered on a case-by-case basis. As you know, core participants were asked to pre-submit questions in advance of this preliminary hearing, so I'd like to take some time to speak to the points raised. I believe most of these questions will have been covered in the course of today's proceedings already. However, there were a number of specific questions raised that I will now address. Evidence. I've received a number of questions regarding what types of evidence the inquiry will consider during the course of our health and social care hearings. We will not publish evidence proposals for the impact hearings. I may consider doing so for the implementation hearings and decision-making hearings. Proceedings for these hearings will be shared nearer the time. One question specifically mentioned evidence relating to population triage and DNACRP, do not attempt cardiopulmonary resuscitation decisions, decision-making in hospitals and social care settings. This is an area where we have already collected evidence and will consider further during the course of our investigations. Frontline workers. I have been asked to confirm if workers and workplaces will be considered in the impact hearings. The inquiry will of course hear evidence from frontline workers. This will likely take place in the next tranche of hearings early next year. Staff will be approached directly rather than through their employers. The inquiry is in its evidence gathering stage and is focusing on the impacts felt in relation to health and social care. The terms of reference in focus at present are G, in care and nursing homes, the transfer of residents to or from homes, treatment and care of residents, restrictions on visiting, infection, prevention and control, and inspections. H, the provision of healthcare services and social care support, including the management and support of staff and the recognition, involvement and support of unpaid carers. I, the delivery of end-of-life care and the use of DNACPR. Again, do not attempt cardiopulmonary resuscitation decisions. There will of course be staff who don't fall naturally within the themes. We are actively considering this and do not wish for anyone to fall between the cracks. We will provide further information in the course of our investigations. Long COVID. I've been asked how the inquiry will address the issue of long COVID. As many of you will be aware, following a legal opinion from the advocate and junior counsel to this inquiry, Mr. David Turner, I determined that certain matters relating to long COVID fall within the inquiry's remit. This was because the existence and effects of long COVID are relevant to the handling of the pandemic in Scotland, and those affected by long COVID will be relevant to the scope of the inquiry. Mr. Turner's full opinion can be found on the inquiry's website for those with an interest. The inquiry is in its evidence gathering stage and is focusing on the impacts felt in relation to health and social care. The terms of reference in focus are, and I have already stated these, so I won't repeat them again. They are G, H and I, which I read out just a moment or two ago. Evidence will be sought in respect of long COVID, particularly in respect of TOR H. One question specifically mentioned evidence relating to population triage, and again I think I've covered this, so I don't need to repeat that this is an area which we've collected evidence in and will consider further during the course of investigation. Some core participants have also asked for opportunities for their members to provide evidence to me as chair, which would not be made public. I would invite all these core participants with an interest to make a formal request to counsel to the inquiry, and if a request is approved, this will be arranged by the inquiry, policy and external relations team. Disproportionate impacts. One question asked what the Scottish COVID-19 inquiry is going to do to specifically address the issue of race in the first hearings. On the issue of equalities and any disparities or unequal impacts, I am bound in the terms of reference to consider these as I deem appropriate and necessary. In preparing for the hearings, we have been gathering evidence from organisations representing those with protected characteristics and other disadvantaged groups where it is relevant to each of the 12 areas included in the terms of reference, including consideration of any disproportionate and intersectional impact. Dr. Croft's report. I have received a number of questions concerning the status of the report and evidence provided by Dr. Ashley Croft to the inquiry regarding the epidemiology of COVID-19. To set the report in context, prior to commencing hearings, we considered it appropriate to explore the scientific position at the relevant time. We instructed Dr. Croft to provide an account of this. Dr. Croft is a public health physician and epidemiologist who has undertaken and published research on a wide range of public health issues, including issues relating to COVID-19. Dr. Croft's report was commissioned to form the basis for future discussion in the inquiry and to provide some scientific context for the work that will follow. His report will sit alongside other existing academic research the inquiry has received and will receive in future, covering specific areas in more detail. The contents of Dr. Croft's report, as with any expert commissioned by the inquiry, should not be seen to preempt the eventual conclusions and recommendations I will eventually make. The views expressed in Dr. Croft's report are his own professionally informed opinions and were provided by the inquiry to inform core participants, interested parties and members of the public, and to form the basis for future discussion in the inquiry. As is the case with all commissioned advice and research, I will consider all relevant material. I will assess it and give it the weight I consider to be appropriate, taking into account all the relevant circumstances. I have also been asked to provide further details on the time frame for core participants to have the opportunity to respond to Dr. Croft's report and his presentation in Dundee last month. Core participants will of course have an opportunity to apply to the inquiry for questions they may wish to be put to Dr. Croft with regard to his presentation. This will necessarily take place at a date later in the lifetime of the inquiry to enable core participants to consider the conclusions presented in Dr. Croft's report in the context of the additional evidence presented in the course of the inquiry's work. Careful consideration is being given to scheduling, and core participants will be given appropriate notice ahead of any session to enable them to prepare questions which will be submitted to Inquiry Council for consideration. I also think it is important to address some of the questions asked regarding why this inquiry has taken a different approach to the UK inquiry with regards to the use of an expert presentation. As with all statutory inquiries, it is for the Chair to determine the structure of investigation and hearings. In line with our memorandum of understanding, we have opted not to duplicate costs in commissioning a very similar exercise to that undertaken by the UK inquiry. Where the UK inquiry has commissioned expert reports, such as that produced by Professor Heyman, these are available to us. As is the case with all commissioned advice and research, both by the UK inquiry and this inquiry, I will consider all the relevant material and give it the weight I deem appropriate, considering all the circumstances. Evidence from expert witnesses. Questions have also been raised about whether I plan to instruct any additional expert witnesses during the course of proceedings. As I have previously discussed, the inquiry is an inquisitorial process, and in the course of progressing work to fulfil its terms of reference, I will decide whether and which experts I wish to instruct. Where an expert is brought to a hearing, I wish to reassure core participants that they will have an opportunity to apply to ask questions to the expert. Any documentary evidence relied upon at the hearing will also be disclosed to core participants with leave to appear prior to the hearing. The inquiry has already conducted some roundtable meetings with experts and key organisations to help gather the evidence we hope to capture. The Portfolio 4 team, led by Ms van der Vesterhudsen, KC, commenced roundtables with Colleges Scotland on 24th August and will continue through the week of 28th August. Similar roundtables have been set up with Universities Scotland. Where the inquiry considers roundtables to be most effective, it will consider using them. I understand some core participants have also asked whether the inquiry may be willing to fund the instruction of experts by core participants to assist with their preparation for hearings. There will be no blanket permission or denial of such a request at this stage. If a core participant strongly felt that it would not be possible for them to prepare fully without the input in an advisory rather than investigatory capacity to help them understand technical evidence advanced, the inquiry will consider that request with regard to its overarching duties and in particular with regard to proportionality and fairness. Any request for funding for such expert input will need to be considered in context. In principle, if a strong case were to be made, and I consider it appropriate to do so, the inquiry could grant such a request. It may be, for example, that multiple core participants are asked to jointly instruct an expert to ensure proportionality, or some other limitation or expectation may be placed on parties seeking to secure such funding. This, however, I stress, will need to be considered in context and on a case-to-case basis. While we would not envisage that such expert input would be required, for example in the context of the impact hearings, it may be that this is a justifiable request with regard to particular aspects of the inquiry's work in due course, and I will turn my mind to such requests as and when they are made. Funding. Bear with me. I think I've said already this computer closes down from time to time, and so I need to refresh it. Funding. In terms of what legal fees can be claimed for preparatory work for public hearings, the initial interim award and accompanying documents set out a range of activities for which funding can be made available, and we are currently working to confirm the final scheme for the award of legal expenses. We hope to have that ready and published to all legal representatives by early October. Until the work to put in place structures for the final award has been concluded, fees submitted will be assessed with reference to the interim award scheme. In terms of whether work charged to the UK inquiry for work done with regard to their terms of reference, we cannot provide assurances that that work will necessarily be funded with regard to this inquiry. Specifically, we cannot take the view it would necessarily be fair to double fund for work already done. Any claim for legal expenses will need to be tied to the ongoing work of the Scottish inquiry at a given time and will be considered on its merits by the inquiry. We will, however, consider how best to reflect these issues in the ongoing work on what will be the final funding award. Operation of the hearings. A number of the questions we have received related to the practical operation of our hearings in relation to the publication of transcripts and the option for remote participation. The proceedings will be live streamed and as such can be viewed by as many people as want to access them. In terms of individual requests for participation in hearings without attending in person, we are considering the needs of individuals on a case-by-case basis with a view to facilitating remote access where appropriate to do so. We are presently considering requests from people who wish to participate in hearings but cannot do so by attending in person. the inquiry will produce a transcript of each hearing, which will be made available on the website as soon as practicable. Now, that concludes rather more expeditiously than we had necessarily thought the introductory remarks and the answers to some of the questions which have been posed by myself and by Mr. Gale. We're slightly ahead of schedule. I'm told that lunch isn't available for another 7 minutes. I check, and I apologise for such expedition. I think, however, the sensible thing to do is, bearing in mind that luncheon is not available until 12:30, we'll give you an hour from 12:30, and instead of starting again with any questions that may remain at 2 o'clock, we'll start at 1:30. There's always the prospect we might finish earlier than the anticipated time, which I'm sure no one would object to. So thank you very much for listening this morning. I appreciate it's been a lengthy session.
No, I'm not
No.
on.
I think that's up to be on again. I'm sorry, I apologise. I've been reminded I should have told you that anyone who wishes to ask a question in the afternoon session, could they please do so at the reception, is that correct? At the reception, please. Thank you very much indeed.